said that backwards. So even if those seeds blew across the road and grew in another farmer's field, Monsanto could go after them, even though it was accidental, for having that seed. In copyright, you can both simultaneously create something and then not get in trouble. But if Robin Gay's family can show that Robin Thicke had access, because well, Robin Thicke's a soul singer and he probably listened to a lot of Marvin Gaye growing up, I don't think Robin Thicke has a lot of footing to stand on there. Although, strangely enough, he sued Marvin Gaye's family first to prevent them from suing him. So a little preemptive strike there, I guess. I don't know how effective it'll be. So just a quick rundown again. Copyright, original works of authorship fixed in a tangible medium of expression. And those are not just ideas. You can't just say, I have an idea and copyright that. You actually have to put it down in something. Patents, we talked about an exclusive license protecting your work for a term of 20 years. That's in the US. Other countries have slightly different things. Monsanto. And then trademark or a service mark to prevent consumer confusion. And you have to file that with the United States Patent and Trademark Office or within a state. So a little bit specific. Copyright, automatically granted. So what does that mean? Who here has a copyright? Who here has taken notes for this class or any other class? Keep your hands up. You guys all have copyrights. All that's needed is an original work of authorship in a tangible medium. So that means those notes you're taking, they're not directly exactly what a professor is saying. It's what you think or what you're learning from the class. You're putting it in a tangible media, whether writing it down or typing it on a computer. You're automatically granted a copyright. You can't enforce it against anyone until you register it, at which case if somebody stole your notes and then your notes that were a script and made it into a movie, then you can go after them for damages. But you have a copyright already existing, and that runs through the world due to various treaties and stuff. Around the world. You can ignore the just not granted because I forgot to delete that from something else. Here's the reason to get a lawyer on that though. This is the United States Code, so you often see USC, title number 17, which covers just copyright. Watch the little bar over here on the left-hand side of your screen. No, you're right. Right. Side of your screen. So this is section 101 definition. Still going. Still going, still going, still going, still going, still going. Oh, and now all of a sudden, section 102, subject matter for copyright. This is what us lawyers get to go through in our copyright class and in detail. But if you look at how long this section is, like each one has a specific situation and clause on when copyright applies and when it doesn't. So this is just the quick motion, but unless you want to become an expert in all of this, which is a pain in the butt, it's worth asking the lawyer, because they've studied this. But a copyright protection subsists, blah, 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 in original works of authorship, so you thought of it, or you changed an idea, or you came up with something, in a tangible medium of expression, now known or later developed. That was added more recently, just because as technology changes, who knows what we're going to be writing stuff on shortly, you know? If you didn't do it on an iPad before, if they hadn't specified iPad, that's how it would be. But these are the categories that tangible medium of expression that can be perceived, reproduced, or otherwise communicated. So you have to be able to at least give it to somebody. But you can get them in literary works, musical works, dramatic works, pantomimes and choreographs. So anyone's here a mime, you can now copyright things. That is a recent change. Pictorial, motion picture, sound recording, architectural works, some of the normal stuff that you would expect. So I need to escape from this. Patents. Again, a limited exclusive license to the creator, but you must file with the United States Patent and Trademark Office and be granted a patent. Just filing doesn't do it. You actually have someone review your patent to say that it's okay to move ahead, that nobody else has come up with this in the past, you're not stealing from someone, or that it's patentable material, so it's not obvious to everyone. So you can't just, you know, this is how you make a latte, oh, I'm going to patent that because then everybody that works at Starbucks or any coffee shop will be doing it because there's no patent on it now. Well, it's kind of obvious how that's done. So that you could do. As we said, even innocent infringers is still liable. So even if you accidentally steal something because you have a new tech startup, say you've got drones or something that you're doing for aerial surveillance, if you accidentally use somebody else's wireless technology or their flight capabilities or something like that, they could come after you. This comes up bigger later because patents are very valuable, and patent trolls come after a lot of startups, so we'll go over that in a second. But you guys have seen kind of what's going on with Apple and Samsung. They keep suing each other over all kinds of stuff, and the judge gave them $1 billion settlement one side and then reduced it and changed it. That's going to keep going on for a long time. Patents, they're guaranteed in the Constitution if you actually want to know. And what is eligible to be patented? Well, another one of these codes, U.S. codes. Any new and useful process, machine, manufacture, or composition of matter. So you hear that process, so how to do something can be patented as well as a specific machine or something like that. Or composite matter, or maybe useful new subject conditions, requirements, and file. Notice there's no list of unpatentable items, so you can always try to get something patented, because the courts right now have said anything under the sun except, but then they don't say what the except is. So there's this big circle with a couple of holes that haven't been filled in. That's how we visualize it. This is what a patent looks like. This is just a cover page. There are many pages behind this actually detailing all the things. But it has a patent number. It has the dates for filing, priority, and issue. Priority becomes a concern because if two people have the same idea, it's whoever files it first. So you have to go through that. The inventor, the technology field, prior art, so you can, prior art is what you're drawing on, so if you're using other patents in the past, how they combine together. Examiner, prosecuting attorney, abstract, et cetera, et cetera, et cetera. And even if they grant a patent, later on, they can actually invalidate a patent because it's been shown that that knowledge was done before. I don't have the example here, but you know those lovely little coffee warmers that sit around the cup that are cardboard? Somebody tried to patent those, and they got it, and then later it was taken away because they were like, wait, no, that's kind of common knowledge, and somebody else did it before, and all that kind of stuff. So why it's concerned to you? Because of patent trolls, especially if you're starting up your own company. Patent trolls do something, they basically either buy existing patents or come up with their own, file them, but never intend to use them, and then come after a lot of startups or people that are using the technology, use intimidation to say, give me a bunch of money, because if not, I'm going to take you to court, which is going to cost you more money, and go through this. So it can really affect a startup company. As it said here on one of the things, average amount spent by startups fighting patent trolls, if they come after you, $168,000 fighting outside of court, $850,000 in court, and then settlement, $340,000. You imagine how many zeros it takes to get through those and how many you're starting up with. So that's why it can be a concern. Trademarks, the next thing, which we talked about, the whole idea is to prevent consumer confusion. So basically when you go to a store and you're buying a specific product, you know you're getting it from that manufacturer, so the quality's not going to be shoddy or anything like that. So if you're going to go buy an Apple computer, you know it's an Apple computer, and it's not some knockoff that just put the logo on. So that's the idea. But you must file to get a trademark, and you usually file with the United States Patent and Trademark Office, but you can also file with the state, just lesser protections. An example of that is, has anybody ever been to Burger King? So you've been to Central Illinois, where the original Burger King is, the mom and pop startup. There was a Burger King that actually started in 1954, I believe, in Illinois that got a state trademark. So they still operate as Burger King in Central Illinois, and the big national Burger King franchise can't come anywhere within that 150-mile radius, which is their territory and their trademark. They can go anywhere else in the world, but that Burger King, that original one, still has a state trademark. So anyway, that's They had it first. Remember, we were talking about WWE, who had the mark first and all that. So they, in a settlement, that's how they came up with that. Trademark can pretty much extend to worldwide protection once you get U.S. protection through a bunch of treaties. You just have to file a little bit more paperwork. It starts at $275 and goes up. You can do this yourself. It's not that difficult on the U.S. Patent and Trademark Office, or you can get an attorney because they usually will come back with questions and things like that. So here's a couple examples. This one I think was just filed yesterday for trademark. Hell's Angels is suing Young Jeezy for stealing their jacket design. Whoever knew that the Hell's Angels had trademarked their jacket design? But apparently they did. Who thinks they're infringing here? Do we think Hell's Angels are going to win? Or do we think Young Jeezy's is different enough so that no one will be confused that this is a Hell's Angels jacket? Everybody can see the difference right now. What if you're 100 feet away? Where are you going to be at? This is how the courts have to decide. Basically, a jury gets in and has to determine, based on the laws, is this close enough that I'd be confused? I think Hell's Angels has a great thing. Here's another example of a bunch of infringing trademarks. Starbucks around the world has filed suits against all these kind of knockoffs that are stealing their old logo. That says KFG, not KFC. Which, my understanding, at least in Japan and in Asia, KFC is actually a little bit of a higher scale restaurant than what we think of here. So it's a little more valuable. This is my favorite. How many trademarks are they stealing off right there just for a restaurant? Who associates Nike with a restaurant? McDonald's logo, Nike's logo. Yeah, I mean, it's kind of like, has anybody seen like flip-flops when you go on, if you went on spring break or something like that, that have the Puma and Adidas and Nike logo on them? Yeah. Go ahead.
So you said even if it's in another country, if they're stealing the copyright, you can still sue them if they're in another country?
On a copyright, yes. This is a trademark. Due to international treaties, TRIPS, TRIPS Plus, WPO, you guys don't care, but there are enough international treaties that if you register most of your marks in here, and you can also do international registration, patents are more complex because you got to do it in every country, and every country has different rules. But copyright and trademark, if you've done international filing as well, yes, you can go after people all over. So, all the things that we talked about thus far, except specifically for patents, if you want to do these for your company, but you don't really have the money to get a lawyer, right now you have the access to the University of Nebraska Law School Entrepreneurship Legal Clinic. The guy in the middle is Professor Brett Stokes, and he has 8 or so senior attorneys every semester that will do these things for you. So if you come in as a client, you just have to fill out an application, and then he tries to assign it to the correct people. So Pickett, which we talked about before, is one of the clients, and we've done a number of things for them. So if you need to file a corporation, if you need to get a partnership agreement, if you need to go through and you want to trademark your logo or something like that, they will do it for you for free, which is the right price at this point. Except for any of the legal filing fees that you have to do, like that trademark fee and stuff like that. So it's a great resource right now to be aware of. This is the website, and that's all the things they do. Entity selection, which means what kind of company do you want to start up. And they'll sit down and go through all the different ideas. So LLC versus a corporation versus an S Corp versus a C Corp versus whatever. They'll sit down and go over all that with you and help you work through it. Negotiating leases, counsel with financial matters, so if you want an investor to come in, regulatory and compliance. So it's kind of a great resource. So, jumping back, what time is it? We get out of here at
4:45.
Okay, so I got 15 minutes, great. Anybody have any questions over that point and stuff? Because now I'll just tell stories.
Think about your businesses, and is there something in particular, legal-wise, that he can
And
maybe...
if you think of it later, you can always email me or call or something like that, and I'd be happy to go over it with you. No? All right. So here's a couple of stories that I know. from my experience.